on, ask as many questions as you need to understand. So what we'll do today is just give you a run through of where we are at the moment in terms of the Employment Rights Bill roadmap. So there's some changes that have been confirmed that are already in place and some that will come into place over the next period. So the confirmed changes that we know already is the Employment Rights Bill finally gained its royal assent on the 18th of December last year. And there'd been quite a long period of time where it was going backwards and forwards in Parliament and lots of debates around particular areas. Um, you will have seen in the press and certainly through our updates that it went backwards and forwards throughout most of last year. And as quick as we thought there was an answer on something, it did change again. So it's been a little bit of uncertainty. The government had said all along that they would introduce the Act over the next 2 year period. And that is still something that is in place. So some changes have already taken effect, which we'll talk to you about today. And some of them are coming in between now and 2027. So the ones that are already in place are a Paternity Leave Bereavement Act, which come into place on the 29th of December last year. And that act means that if a mother or adopted mother of a child dies during childbirth or within a year of the birth or adoption, the employee can take statutory paternity leave without the need for service. So already in place, if you have any bereavement during childbirth or adoption, the surviving partner can take that leave. And the other change that's already in place is from the 1st of December, the window for ACAS early conciliation has doubled. So prior to December, if anybody went to ACAS to raise a tribunal claim against an employer, ACAS would enter into early conciliation. And that's where they would liaise with the employer to try and reach an agreement or a compromise prior to it going to tribunal. Now, up to December, ACAS had 6 weeks in which to try and reach an agreement, but that doubled to 12 weeks. So currently, if an employee goes to ACAS about yourselves, ACAS have got 12 weeks to try and liaise with you to reach an agreement on that. And then there's some changes coming in April. So I'll talk you through the changes. Some of them won't apply, obviously, to a lot of you. So if you've got specific questions about ones that affect you, just let us know. So one of the changes that's coming in April is a day one right to paternity and parental leave. So at the moment, for employees to take paternity leave or parental leave, which is the unpaid block of time to look after a child, they need to have 26 weeks service to do so. This will now become a day one right. So from the first day of employment, somebody can take paternity leave or they can request a block of unpaid parental leave. Now, the pay isn't changing on this, so the leave will still be unpaid, but it means that you may get requests from day one of employment or indeed any time up to the 6 month period. The other change on screen here is the really big one, and this is the one that everybody needs to be aware of and everybody needs to be preparing for. So, with regards to sick pay, there's two changes coming in. So, the first one is that at the moment, the first 3 days of sickness are unpaid waiting days. From April, those unpaid waiting days will go, and SSP will be payable from day one of sickness. So, there'll be no 3 days unpaid anymore, it will be paid from day one. There's then another change, which is in order at the moment to get SSP, people have to earn £125 a week, and that's the qualifying earnings to be able to get SSP. So if you've got somebody on your team, for example, who is very part-time, or perhaps young workers who are on a lower rate of pay that don't earn £125 a week, at the moment, if they're off sick, their sickness is unpaid. From April, they will be paid 80% of their pay. So the statutory sick pay entitlement will be SSP or 80% of wages, and it will be the lower of the two. So there will be businesses who need to be budgeting potentially for sick pay to be taken by people who at the moment don't qualify for that pay. And like we say, for all businesses, you need to be budgeting for your SSP to be paid from day one. Now, we'll talk a little bit later on about some practical things you can do to prepare for that, but it's really important to be aware that these changes are both coming and they're both confirmed for April. Other changes in April include the establishment of a Fair Work Agency. So the Fair Work Agency are a department or an agency that will be established by the government, And they will have powers to do things like spot checks on businesses. They don't just have to respond to complaints. And they will have the power to enforce workers' rights. So, where a complaint is made, or where the government believe they have reason to investigate a company, or they just want to spot check the company, it will be the Fair Work Agency or the FWA who are very likely to do that with you. Now, one of the other powers that the Fair Work Agency will have is where an employee doesn't want to take a company to tribunal, the Fair Work Agency will have the authority to pursue that on the worker's behalf. So even though you may have an employee that says, well, I'm not interested in, excuse me, in legal action, I don't want to take my employer any further, the Fair Work Agency will be able to pursue that claim on behalf of a worker. And their rights will extend to things like holiday, any kind of breach of contract. So it's really important to be aware that this agency will come in and may audit or visit sort of companies. Minimum wage increases obviously happen every April, but this year there's quite a jump. So the 18 to 20-year-olds will go up to £10.85 an hour. That's right. 16 to 17 and apprentice rate will go up to £8 an hour, and the over 21s to £12.71. So quite a jump across all the bands. But as you can see, the gap between the bands is starting to close. And obviously, that's something that Labour have spoken about in terms of pay for a job, not pay for an age. So those gaps are likely to continue to close going forward. And then there's a change to collective redundancy protective awards. So these kick in where you make a redundancy, which is a collective or a large scale redundancy of over 20 people, and it's 20 people within 90 days. So it's probably unlikely to apply to a lot of the businesses here, but just be aware that if you are making redundancies where you're going to lose more than 20 people over that period, at the moment, the award for failure to do that properly is 90 days pay, and that will increase to 180 days pay from April. So a doubling of the award that you could potentially be fined for. There will be further protections around whistleblowing and looking at a ban of NDAs, so non-disclosure agreements. So where you may have settlement agreements or agreements which relate to harassment or discrimination, they will be exempt from being part of a settlement agreement or part of an NDA. And there will also be some changes to trade union rights. So lots of plans to simplify union processes, to simplify industrial action processes, which again probably won't affect a lot of you here at the moment, but there are further union changes coming, which we'll talk about in a moment. So that's the changes that are coming in April. Has anyone got any questions or anything at all you want clarified on any of that at the moment? No? Okay, we'll carry on. Like I say, if you have, please jump in at any point. And then going into October, a couple of big changes here for October. So the time limit for tribunals will be extended. So at the moment, an employee can take you to tribunal after leaving in it's 3 calendar months minus a day. That will double in October, and they will have 6 months to raise a tribunal claim. So along with the doubling of the ACAS conciliation period, potentially means from the point of somebody leaving, it could be 9 months before the decision is made to go to tribunal, which is quite a long time, compared to where it is at the moment. Sexual harassment laws will be strengthened more, and the responsibility for companies to take all reasonable steps to prevent sexual harassment. Good question there. Has it been clarified what all in the all reasonable steps actually is? It is very vague wording. It is very loose wording. I think it's going to come down to what is ruled reasonable, and using the kind of benchmark that employment tribunals usually use of what would a reasonable employer do. So I would say at a minimum, it's going to be things like risk assessments, um, making sure you've assessed your workforce to look at the risk. Obviously, there will be different risks for different people, but the sexual harassment protection going forward will also extend to any third party, so any customer, any client, even incidental contact with those people. So I think most businesses are going to have some kind of risk, whether you've got employees that are genuinely public facing, working in bars, social care. But even for yourselves that are just office based, there will still be a risk, obviously, of sexual harassment from colleagues, from tenants. So I think a lot of that is going to come down to risk assessments and being able to evidence that you've considered your own business. And then we've got more trade union changes in April. So you will be required from April to give workers a written statement reminding them of their right to join a trade union. Now, whether that will need to be a written letter or part of an employment contract isn't yet clear. And obviously, for those that are retained clients, we'll update your documents for you anyway. But it's not going to be enough just to support people that are in a union. You will actually have to encourage them or remind them of their right to do so. And then for anybody working in the tipping industry, there'll be changes to tipping laws in October. So there'll be a requirement for you to consult with workers and then create a tipping policy. And that policy will need to be updated at the moment every 3 years. So it will need to be regularly updated. And as part of the consultation, staff will have to be given feedback of what's come out of that consultation before the policy is created. I know in the last session we had a couple of people that were in kind of catering or hospitality sectors. So if you do fall into anything like that at all, just make sure you're up to speed on what's required under the tipping laws. So they're the main changes for October. Now, before you breathe a sigh of relief, there's more changes coming in for 2027, but we'll be backdated for this year. Now, we will be sending a graphic round next week, which explains this very clearly. So if you're not on our mailing list and you want to receive it, do let us know. The biggest change out of all of this is the change to unfair dismissal periods. Now, as you know, at the moment, there's 2 years where you can relatively safely terminate a contract, assuming that it's not connected to things like protected characteristics. A lot of Labour's kind of pledge from day one was they wanted that to become a day one right. So people from the first day of employment would have protection from unfair dismissal. After lots and lots of negotiation, it's been settled on 6 months. And that is 6 months to come into effect on the 1st of January 2027. Now, what that actually means, and to put it into very, very simple terms, is anybody that hits 6 months employment on the 1st of January 2027 will have unfair dismissal rights. So anybody that you employ, for example, today, normally would be under 2 years service until February 2028. But that will be irrelevant because from January they will hit their 6 month service. So in effect, anybody who is already in position will gain their 6 months potentially before this date. And anybody you employ now will not be covered under 2 year rulings. So it's really, really important. And we'll talk about in a moment what you can do. But it's really, really important to consider how you are managing probation and reviews and dismissals. Obviously, what nobody wants to happen is you get to October, November, and suddenly realise you've got all these people that are suddenly about to hit their 6 months and make lots of short service dismissals. But I think the reality is, a lot of companies aren't going to be aware that this rule applies to existing staff. So just be mindful of it. Obviously, you need to discuss particular cases, let us know. Hopefully, it's not going to change anything massively, but we will talk to you in a moment about probation, which will be a knock on from this. Um, and then into 2027, a couple of other changes, which to be honest, aren't going to massively affect a lot of companies, but when they do, will certainly be beneficial for staff. So at the moment, the only kind of bereavement leave that's covered in legislation is child bereavement. There will be legislation going forward, which will also affect adult or dependent bereavement. So it will set in statute, what time people can take off. And there is also a ban on fire and rehire, which was due to come in April, and then it was due to come in October, and then last week it's been confirmed that it's now pushed back to 2027. But this will affect occasions where you're trying to consult with your workforce to change a contractual term. Sometimes companies get to the point where you can't reach a conclusion, people aren't negotiating, and you may go through a fire and rehire or a dismissal and re-engagement process. And that is basically where you tell somebody, your contract will terminate today. If you come to work on Monday, you've accepted the new terms. Now, it's always been risky and it's something that's presented when it does happen, it tends to make a lot of media interest. And you've probably heard of cases that have happened. At the moment, fire and rehire in itself is not a standalone tribunal case. So people can only go to tribunal if it's connected to another claim. But when this legislation comes in, it will be a tribunal case in its own right. And that will affect any changes to contracts that are related to a restricted variation. So that's anything to do with pay, working hours, annual leave, shifts. So basically any of the contractual terms. So just be aware that if you are consulting and you've got any inclination at all to go through a fire and rehire or a dismissal and engagement process, just get some advice before you do it because it is going to be much, much riskier and much easier for people to take action where that's done wrong. So they're the main changes that are coming in. Now, there are a few others that certainly will happen or will be announced, and that includes things like gender pay gap reporting, menopause support, other increases to workers' rights. So looking at other things around particularly family leave, flexible working, there's lots of things like that that are still being debated. The other big one, which certainly at some point will come in, is the change to zero-hour contracts and the requirement to make sure that if you are using zero-hour contracts, that they're not exploitative at all. Um, on the back of zero-hour contracts, there will be a predictable working legislation, and that will basically apply in cases where an employee can evidence that over a period of time, which is very likely to be 12 weeks, their shifts have actually been predictable, not 0 hours. So if you had a business, for example, where an employee has worked every single Thursday, Friday, and Saturday for the last 3 months, they would have the right to go to that employer and request that to become their predictable contract. And instead of being 0 hours, they would then be recruited on those terms. So the law around that isn't yet clear how it will work, whether it will be up to the employee to request or the employer to audit and offer. But if you are using 0 hour contracts, it's certainly one to sort of watch out for and be aware that there are some changes coming. So, million dollar question here, how will all of this affect the tribunal system? So we've already seen the changes that it will make to ACAS and to the length of time. It's predicted that as a result of the Employment Rights Act, there will be a 17% increase in tribunal claims. And it's estimated there'll be 21,000 extra early conciliations. There will be 6,900 more cases going through tribunal and around 1,300 cases which require judicial time, which are heard in tribunal courts. Now, on top of the lengthening, obviously, of the ACAS process, there may be that for your own companies, you see more sort of cases and more conciliation coming through. There is another change, which I think is on a future slide, but while we're talking about tribunals, we'll mention it anyway. At the moment, the cap for unfair dismissal in tribunal is capped, so there is a maximum limit that can be paid out for unfair dismissal. Under these changes from the 1st of January, the unfair dismissal cap will be removed. So on top of the additional cases that will go to tribunal, the amount that can be rewarded will actually be removed and it will be a limitless cap for unfair dismissal. So just something else sort of to be aware of. So how can you prepare? I mean, there's some practical things that you can be doing that we would say every company should be doing at the moment. So check your policies and contracts reflect the changes and check that your policies and contracts protect your business. So thinking about some of the risks that may come from this. As we say, if you're on a retained contract, we'll do this for you. But if you're not and you need help sort of reviewing contracts or looking at anything at all, just let us know. Because as with any of these, somebody can only take you to court for breach of contract on the back of a contract. And it's that contract that will protect you. If it's not in place or if it doesn't protect you, it's an automatic risk to yourselves. Really importantly, train your managers and other personnel to make sure they're equipped to deal with this. So if you're not the person that is physically dealing with this day in, day out, and you're delegating that responsibility to a management team or to somebody else, make sure they know and they understand the risk and they understand the changes. On terms of sickness, think about how you record your data. So there is obviously a very real risk that sickness will increase. People are now going to be paid from day one, and people who previously weren't paid will now be paid 80%. So as a result of that, sickness levels are very sort of predicted to rise. Think about how you record that sickness data. So are you doing things like return to work interviews? Are you spotting trends? Are you providing support indeed where support is needed and people are unwell? Look at your processes. So think about things like your return to work interviews, your probation reviews, your appraisals. You may need to budget for sick changes. And obviously keep up to date. Like we say, we'll send you out updates as these happen, but these things are changing so quickly that between us sort of issuing a blog or a webinar, it's changed again. So just try and keep up to date as much as you can. So some practical steps, we'll look at sickness and probation, but they're very, very similar. So review your reporting and think about how you're logging. Whether somebody now is off for 1 day or off for 10 days, there's going to be a cost to your business. So are you doing things like return to work interviews to find out why? Are your managers confident to have those questions? If you've got people in your teams that do suffer with ill health or suffer with disability or with conditions, do you understand what they need and how you can support them? So just start to think about some of those areas. And obviously, budget is the important one. You know, this will cost companies money that it doesn't currently cost money. So if that's something you need to think about your budgets for, then obviously that's important to do so. And then thinking about unfair dismissal. So, like we said, what we know now is that 6 months will come into force on the 1st of April, as on the 1st of January, as an exact replica of the 2 year process at the moment. So, if you're dismissing somebody with under 6 months service as a short service dismissal, make sure your contract enables you to do it. It's very important. But that 6 month period will also need to include their notice. So if you're currently running a 6 month probation and you review probation at 6 months and make the decision it's not working and then issue notice to terminate, you will be outside of the 6 month period. So we are recommending to customers that you make probationary periods 3 months and then you have the option to extend for another month if there's concerns about performance. And then you would be able to issue notice to safely terminate within that period. The thing to be aware of there is obviously some notice periods themselves could be 3 months. So you just need to have a look at contracts. Like I say, for retained customers, we will do this for you and we'll let you know if we need to discuss changes. But just get yourselves in the mindset of thinking about how long those contracts are and how long your notice period is, because you may want to be bringing probationary periods forwards. And again, with those, think about your manager's training, but think about your processes and record keeping as well. If you're reviewing probationary performance and somebody isn't meeting the requirements, it's really important that their documents reflect that. Because what you don't want is to get to 6 months, make a decision to terminate, but then there's no evidence and there's nothing to actually back up that there were any concerns. So it's going to be even more important than it is now that you're doing probationary reviews and you're monitoring performance throughout that time, which will obviously then lead to a decision in some cases. And then just some other considerations. There is guidance available. This is now available. There are some fact sheets available which we can share with you or available on Gov UK. Um, and as we said earlier, there will be a ban on the use of non-disclosure agreements or NDAs where it connects to harassment or discrimination. So whether this is a straightforward NDA or as part of a settlement agreement, it will be unlawful to ban somebody from talking about harassment or discrimination. So again, it just makes it so much more important that you're managing the processes to stop those things from happening. This is what we mentioned earlier. So there's currently an unfair dismissal limit of £118,223 or 12 months pay. And previously, only whistleblowing or health and safety claims were exempt from that. Going forward, there will be no unfair dismissal limit. So it'll be up to the courts what they agree or what they decide is an appropriate payment. So it may make dismissal cases, well, it will make dismissal cases more expensive, but it may also make people more inclined to pursue that route, where it's not so restricted on caps and amounts. So that's a run through of everything that's changing. Obviously, as always, we're happy to take any questions. I think what we will do, Elle, is we'll stop the recording now, and then obviously people can talk a little bit more freely if you have got questions. If anything comes out we think you need